Hello, hello, hello. Amanda, Gen X Alaska, reading the Alaska State Constitution. Here we go. We are on Article 11, Initiative, Referendum, and Recall. Initiative and referendum. The people may propose and enact laws by the initiative and approve or reject acts of the legislature by the referendum. Application. An initiative or referendum is proposed by an application containing the bill to be initiated or the act to be referred. The application shall be signed by not less than 100 qualified voters as sponsors and shall be filed with the Lieutenant Governor. If he finds it in proper form, he shall so certify. Denial of certification shall be subject to judicial review. Amended 1970. Petition. After certification of the application, a petition containing a summary of the subject matter shall be prepared by the Lieutenant Governor for circulation by the sponsors. If signed by qualified voters who are equal in number to at least 10% of those who voted in the preceding general election, who are resident in at least 3/4 of the House districts of the state, and who in each of those House districts are equal in number to at least 7% of those who voted in the preceding general election in the House district, it may be filed with the Lieutenant Governor. Amended 1970, 1998, and 2004. Initiative election. An initiative petition may be filed at any time. The Lieutenant Governor shall prepare a ballot title and proposition summarizing the proposed law and shall place them on the ballot for the first statewide election held more than 120 days after adjournment of the legislative session following the filing. If before the election substantially the same measure has been enacted, the petition is void. Amended 1970. Referendum election. A referendum petition may be filed only within 90 days after adjournment of the legislative session at which the act was passed. The Lieutenant Governor shall prepare a ballot title and proposition summarizing the act and shall place them on the ballot for the first statewide election held more than 180 days after adjournment of that session. Amended 1970. Enactment. If a majority of the votes cast on the proposition favor its adoption, the initiated measure is enacted. If a majority of the votes cast on the proposition favor the rejection of an Recall 36 Act, I think that's a typo, referred, it is rejected. The Lieutenant Governor shall certify the election returns. An initiated law becomes effective 90 days after certification, is not subject to veto, and may not be repealed by the legislature within 2 years of its effective date. It may be amended at any time. An act rejected by referendum is void 30 days after certification. Additional procedures for the initiative and referendum may be prescribed by law. Amended 1970. Restrictions. The initiative shall not be used to dedicate revenues, make or repeal appropriations, create courts, define the jurisdiction of courts or prescribe their rules, or enact local or special legislation. The referendum shall not be applied to dedications of revenue, to appropriations, to local or special legislation, or to laws necessary for the immediate preservation of the public peace, health, or safety. Recall. All elected public officials in the state, except judicial officers, are subject to recall by the voters of the state or political subdivision from which elected. Procedures and grounds for recall shall be prescribed by the legislature. Article 12. General provisions. State boundaries. The state of Alaska shall consist of all the territory, together with the territorial waters appurtenant that's a new word, appurtenant thereto, included in the territory of Alaska upon the date of ratification of this Constitution by the people of Alaska. Intergovernmental relations. The state and its political subdivisions may cooperate with the United States and its territories and with other states and their political subdivisions on matters of common interest. The respective legislative bodies may make appropriations for this purpose. Office of Profit. Service in the armed forces of the United States or of the state is not an office or position of profit as the term is used in this Constitution. Disqualification for disloyalty. No person who advocates or who aids or belongs to any party or organization or association which advocates the overthrow by force or violence of the government of the United States or of the state shall be qualified to hold any public office of trust or profit under this Constitution. Oath of office. All public officers, before entering upon the duties of their offices, shall take and subscribe to the following oath or affirmation. I do solemnly swear or affirm that I will support and defend the Constitution of the United States and the Constitution of the State of Alaska, and that I will faithfully discharge my duties as ... to the best of my ability. The legislature may prescribe further oaths or affirmations. Merit system. The legislature shall establish a system under which the merit principle will govern the employment of persons by the state. Retirement systems. Membership in employee retirement systems of the state or its political subdivisions shall constitute a contractual relationship. Accrued benefits of these systems shall not be diminished or impaired. Residual power. The enumeration of specified powers in this Constitution shall not be construed as limiting the powers of the state. Provisions self-executing. The provisions of this Constitution shall be construed to be self-executing wherever possible. Interpretation. Titles and subtitles shall not be used in construing this Constitution. Personal pronouns used in this Constitution shall be construed as including either sex. Law-making power. As used in this Constitution, the terms by law and by the legislature, or variations of, are used interchangeably when related to law-making powers. Unless clearly inapplicable, the law-making powers assigned to the legislature may be exercised by the people through the initiative, subject to the limitations of Article 11. Disclaimer and agreement. The state of Alaska and its people forever disclaim all right and title in or to any property belonging to the United States or subject to its disposition and not granted or confirmed to the state or its political subdivisions by or under the act admitting Alaska to the Union. The state and its people further disclaim all right or title in or to any property, including fishing rights, the right or title to which may be held by or for any Indian, Eskimo, or Aleut, or community thereof, as that right or title is defined in the Act of Admission. The state and its people agree that, unless otherwise provided by Congress, the property, as described in this section, shall remain subject to the absolute disposition of the United States. They further agree that no taxes will be imposed upon any such property unless otherwise provided by the Congress. This tax exemption shall not apply to property held by individuals in fee without restrictions on alienation. Consent to Act of Admission. All provisions of the Act admitting Alaska to the Union, which reserve rights or powers to the United States, as well as those prescribing the terms or conditions of the grants of land or other property, are consented to fully by the state and its people. Approval of Federal Amendment to Statehood Act affecting an interest of the state under the Act. The federal statute or proposed federal statute that affects an interest of the state under the Act admitting Alaska to the Union is ineffective as against the state interest unless approved by a 2/3 vote of each house of the legislature or approved by the people of the state. The legislature may, by a resolution passed by a majority vote of each house, place the question of approval of the federal statute on the ballot for the next general election unless in the resolution placing the question of the approval, the legislature requires the question to be placed before the voters at a special election. The approval of the federal statute by the people of the state is not effective unless the federal statute described in their solution is ratified. Another typo, is ratified by a majority of the qualified voters of the state who vote on the question. Unless a summary of the question is provided in the resolution passed by the legislature, the lieutenant governor shall prepare an impartial summary of the question. The lieutenant governor shall present the question to the voters that a yes vote on the question is a vote to approve the federal statute, amended 1996. Article 13, Amendment and Revision. Amendments. Amendments to this Constitution may be proposed by a 2/3 vote of each house of the legislature. The lieutenant governor shall prepare a ballot title and proposition summarizing each proposed amendment and shall place them on the ballot for the next general election. If a majority of the votes cast on the proposition favor the amendment, it shall be adopted. Unless otherwise provided in the amendment, it becomes effective 30 days after the certification of the election returns by the lieutenant governor, amended 1970 and 1974. Convention. The legislature may call constitutional conventions at any time. Call by referendum. If during any 10-year period a constitutional convention has not been held, the lieutenant governor shall place on the ballot for the next general election the question, shall there be a constitutional convention? If a majority of the votes cast on the question are in the negative, the question need not be placed on the ballot until the end of the next 10-year period. If a majority of the votes cast on the question are in the affirmative, delegates to the convention shall be chosen at the next regular statewide election unless the legislature provides for the election of the delegates at a special election. The lieutenant governor shall issue the call for the convention. Unless other provisions have been made by law, the call shall conform as nearly as possible to the act calling the Alaska Constitutional Convention of 1955, including but not limited to number of members, districts, election and certification of delegates, and submission and ratification of revisions and ordinances. The appropriation provisions of the call shall be self-executing and shall constitute a first claim on the state treasury, amended 1970. Powers. Constitutional conventions shall have plenary power to amend or revise the Constitution, subject only to ratification by the people. No call for a constitutional convention shall limit these powers of the convention. And then Revision Article 14, Apportionment Schedule. It was repealed in 1998. Oh my goodness, excuse me, I don't even know what that is. Love ya, bye!